for Civil Party Group 3, and Mr. Philip Cannon is also counsel for Civil Party Group 3. Thank you, Mr. President.
អង្គសវនាការឋានសំណុំរឿងលេខ001ចុះថ្ងៃទី18ខែកក្កដាឆ្នាំ2007 ដែលមានជនជាប់ចោទកាំងកេយូ
The judgment of the trial chamber against the accused Kang Kek-yew alias Doch was pronounced on the 26th July 2010.
ឆ្នាំ 2009 និងបញ្ចប់កិច្ចពិ
The
ភាក្សា
trial
ដោយ
started
នៅថ្ងៃទី
and ended on the 28th November 2009.
ខែកក្កដាឆ្នាំ 2010 អង្គជំនុំជម្រះសាលាដំបងនៃ
And the trial chamber issued its judgment on the 26th of July 2010.
ការផ្តន្ទាទោស
The chamber finds Kang Kek-yew guilty
ជនជាប់ចោទកាំងកេយូហៅដូចមានពិរុទ្ធភាពតាមមាត្រា
pursuant to Articles 5, 6, and 29 new of the ECCC law on crimes against humanity, persecution on political grounds, subsuming the crimes against humanity of extermination, encompassing murder, enslavement, imprisonment, torture, including one instance of rape and other inhumane acts, and grave breaches of the Geneva Conventions of 1949, willful killing, torture, and inhumane treatment, willfully causing great suffering or serious injury to body or health, willfully depriving a prisoner of war or civilian of the rights of a fair and regular trial, and unlawful confinement of a civilian. These crimes were committed in Phnom Penh and throughout the territory of Cambodia from 17 April 1975 through 6 January 1979. The chamber sentences Kang Kek-yew to a single sentence of 35 years of imprisonment with a reduction of 5 years due to the violation of Kang Kek-yew's rights occasioned by his illegal detention by the Cambodian military court between 10 May 1999 and 30 July 2007. The accused is entitled to credit for the entirety of his time spent in detention, that is from 10 May 1999 to 30 July 2007, under the authority of the Cambodian military court, and from 31st July 2007 until the judgment becomes final under the authority of the ECCC. For the national crimes, the judgment does not assess the national crimes. In regards to Article 501, 506 of the 1956 Penal Code and Article 3 new of the ECCC law. Declarations. All civil parties named under paragraph 645 to 650 have suffered harm as a direct consequence of the crimes for which Kang Kek-yew has been convicted. The chamber shall compile all statements of apology and acknowledgements of responsibility made by Kang Kek-yew during the course of the trial. This compilation shall be posted on the ECCC official website within 14 days of the date of this judgment becoming final. It rejects all other civil party claims. Detention. The trial chamber convicts the candidate in the detention until the judgment becomes final, or until the Supreme Court chamber decides on the appeal. Civil party status. 24 civil party applications listed in paragraphs 647, 648, and 649 have been rejected by the trial chamber. The judgment was pronounced in public on the 26th of July 2010 and subject to appeal as set out in the internal rules of the ECCC. The appeal. The Supreme Court chamber was seized of the appeal against the judgment by the following parties. The co-prosecutors filed notice of appeal on 16 August 2010 on the error of law made by the trial judgment, including the discretion and the cumulative conviction. The co-prosecutors filed their notice of appeal and the appeal in October 2010 and in Khmer on the 18th of October 2010. There is no response from other concerned party to the filing of the co-prosecutors. The co-defense lawyers filed their notice of appeal on 24 August 2010 on the error of law that the judgment cannot be accepted, in particular on the personal jurisdiction and the single sentence of 35 years imprisonment. The appeal was made on the 18th of November 2010 and with the amendment subsequently. The co-lawyers for Civil Party Group 3 filed their response in December 2010, and then the co-prosecutors filed their observations on the appeal, the corrected appeal dated 16 March 2011. The co-lawyers for the accused replied to the response by the co-prosecutors on the 14th of January 2011 in Khmer and in English on the 17th February 2011. Co-lawyers for Civil Party Group 1 filed their immediate appeal on the 16th of September 2010 against the rejection of Civil Party status. This immediate appeal dated 30 September 2010 of the Supreme Court chamber. The lawyers for the Civil Party Group 1 filed additional brief on the 18th of October 2010. There is no response from other parties to that filing. The co-lawyers for Civil Party Group 2 filed their notice of appeal on the 24th of August 2010 and on the 6th of September 2010 against the judgment in regards to the rejection of 5 civil party applications and on the issue of reparations. They filed the appeal on the 25th of October 2010 and the 5th and on the 5th of November 2010 in English. In Khmer on the 22nd October 2010. There is no response by other parties to these filings. The co-lawyers for Civil Party Group 3 filed their notice of appeal on the 20th of August 2010 against the rejection of 6 civil party applications and on the decision on reparations, and they filed their appeal in October 2010 in English and in the Khmer language on the 6th of October 2010. There is no response by other parties. On the appointment of the rapporteur judges, according to Rule 108, the Supreme Court Chamber's President appoints rapporteur judges to review the appeals into 4 categories. 1, on the personal jurisdiction by Judge Sam Sarewut and Judge Jaya Singhe, and on the issue of crimes against humanity by Judge Sindrit and Judge Millard. On the issue of the sentencing, Judge Sindrit and Judge Noguchi, and on the status of civil parties and reparations, Judge Janaran and Judge Millard. On the additional material and evidence based on the request by the lawyers for the defense and lawyers for the civil parties, Group 1, 2, and 3, they request to file additional material to the Supreme Court Chamber. And on the 25th of March 2011, we accepted to receive those new evidence and materials. The Supreme Court Chamber would like to remind all parties that during their oral submission they need to bring to light those new evidence. Now we will open the floor for the first section of the appeal, that is in regards to personal jurisdiction, and I would like to give the floor now to the rapporteur judge. ដោយបានការឯកភាពពីលោកសហចក្រមរបាយការណ៍នេះហលសាយាសិង្ហេ Judge Samtariwood, with the agreement from my co-rapporteur, I would like to now present the personal jurisdiction section of the appeal. The trial chamber observed that there is no preliminary objection to personal jurisdiction raised by the defense at the initial hearing, and the trial chamber rejected the later submissions on personal jurisdiction by the defense as belated. The trial chamber addressed the issue of personal jurisdiction on its own motion pursuant to Internal Rule 98.3 and concluded that the accused was among those who were most responsible. The trial chamber considered that there was no need to examine the issue of whether the accused was also a senior leader of Democratic Cambodia. Submissions by appellants. The defense appeals against the trial judgment on the ground that the trial chamber erred in fact and in law by deciding that the accused falls within the personal jurisdiction of the ECCC. The following are the defense supporting arguments in the accused appeal brief. The trial chamber erred in rejecting the defense's jurisdictional challenge as untimely under Internal Rule 89. The trial chamber erred in constructing the personal jurisdiction of the ECCC as two separate and distinct categories of persons, senior leaders and those who were most responsible. And since the appellant was not a senior leader of Democratic Cambodia, he therefore cannot be amongst those who were most responsible. And the trial chamber erred by failing to consider exculpatory evidence. The defense requests that the Supreme Court chamber order the release of the accused and finds that the detention of Kang Kech Yew has been a form of protection accorded to a witness. The co-prosecutors respond that defense arguments on personal jurisdiction that fail to meet minimum pleading requirements should be disregarded by the Supreme Court chamber, and also submit that under Internal Rule 89, the defense was required to raise any objections to jurisdiction in the initial hearing. Not only did the defense fail to do this, but the defense also indicated that it did not intend to challenge personal jurisdiction. The trial chamber correctly constructed the personal jurisdiction of the ECCC as two distinct categories of persons, senior leaders and those who were most responsible. And the trial chamber correctly determined that the accused was amongst those who were most responsible. In its written reply to the co-prosecutor's response, the defense submits that the co-prosecutors rely too heavily on the jurisprudence of international courts. International law should only be used at the ECCC in certain circumstances that are not present in this case. As such, international jurisprudence cannot be used to place the accused within the category of those who were most responsible, and the co-prosecutors misinterpreted Internal Rule 89 in that personal jurisdiction is challenged on the basis of evidence adduced during trial. Civil Party Group 3 filed a written response to the accused appeal brief, requesting the chamber to reject the defense arguments as manifestly unfounded. Thank you. The President, the security officer, can you bring the accused to the dock?
មុននឹងឲ្យជនជាប់ចោទ
The president, before the accused is invited to make his observation regarding the appeal, in this proceeding, you are innocent until found guilty. You had the right to be informed of the charges against you, as I just read out, and you had the right to legal representative of your choosing. And during each stage of the proceedings, you can exercise the right to remain silent. And you are invited to make a brief observation for the appeal, and you have 5 minutes, so please use the time appropriately. The accused. Good morning, Mr. President. Good morning, Your Honors. Regarding the appeal, my main point in the appeal is on personal jurisdiction. So this is purely a legal matter. And I give the authority to my legal representatives to act on my behalf, and that is the stand that I am maintaining. Thank you, the President. Thank you for your observation. The President, we just observed that the accused maintained his position regarding the point raised in the appeal, and he gives the authority to his co-lawyers to act on his behalf. You may now return to your seat.
The President, the Defense Counsel is now given the floor to make his oral submission in relation to the personal jurisdiction matter. The floor is his. Counsel Kasawut. Good morning, Mr. President. Good morning, Your Honors, national and international judges, and good morning to everyone in and outside this courtroom. My name is Kasawut. I am representing Kang Kek Eo Elis Duch, the accused, who has found in the judgment of the trial chamber guilty and sentenced to 35 years of imprisonment regarding the crimes against humanity and grave breaches of the Geneva Convention of the 12th of August 1949. According to Articles 5, 6, and 29 new of the ECCC law. Your Honors, under the agreement between the United Nations and the Royal Government of Cambodia, the extraordinary chambers in the courts of Cambodia has been established for the purpose of prosecuting those people who have committed crimes against humanity, war crimes, genocide, and grave breaches of the Geneva Convention of the 12th of August 1949. Under the same agreement, both parties have a shared and common goal is to find justice for Cambodian people and at the same time to bring the national reconciliation and peace to Cambodian people and at the same time respect the sovereign of the Cambodia rather. Under the agreement between the United Nations and the royal government of Cambodia, Articles 1 and 2 new of the ECCC law, the power has been vested with the chamber and that the jurisdictions matter have already been well set. First, the ECCC has jurisdiction to only bring to trial in relation to crimes against humanity, war crimes, genocide, grave breaches of the Geneva Convention of the 12th of August 1949. 2. The ECCC has the power to prosecute only the crimes that were committed between the 17th of April 1975 through the 6th of January 1979. 3. The ECCC has the power to prosecute only crimes that have been committed within the territory of Cambodia. 4. The ECCC has the power to prosecute only the senior leaders of the Democratic Cambodia and those who were most responsible for the crimes. These are the jurisdictional conditions the Supreme Court chamber shall reconsider. As a matter of fact, the jurisdiction comprises of, first, personal jurisdiction, territorial jurisdiction, 3, temporal jurisdiction, and 4, material or subject matter jurisdiction. If the chamber has to finish admission by ending the culture of impunity, it shall consider carefully the crimes committed and also the personal characteristic of the accused. The scope of the jurisdiction has to be well determined by the criminal court because this is very important. Otherwise, it would infringe the rule of law and or the legality